We will be starting in just 2 minutes. Respected ma'am and dear participants, a very good evening to all of you. ID Savraj, member of Legal Vidya, welcome you all to this enlightening 3-day workshop on real estate laws and Rera, organized by Legal Vidya. We are thrilled to have such a distinguished audience with us today, eager to explore the intricate world of real estate and regulations. Before we begin this session, let me briefly introduce Legal Vidya to you all. It was established in the year 2021 with the vision of empowering young lawyers. We are an edtech platform dedicating to empowering young legal minds. We offer a wide range of opportunities, including internship, webinar, workshop, and courses, alongside a platform for publishing your legal article, fostering a dynamic space for legal learning and discourse. Now come to our much awaited workshop over the next 3 days. We are delve into the essential aspect of real estate laws, focusing on fundamental principle, RERA, consumer protection, and the practical news of real estate transaction. With the expertise of our esteemed speaker, we aim to provide you with the valuable insight that will not only enhance your legal understanding but also empower you to navigate the real estate sector with confidence. So before we begin this session, I'm privileged to introduce our distinguished speaker for today's session, Advocate Disha Mahendra Oza ma'am, a specialist in real estate laws. Ma'am offered end-to-end legal solution in property-related matter, including society mergers, 79A processes, recovery of dues, convenience, deemed convenience, and agreement drafting. With extensive experience in cooperative housing society matters, ma'am has been instrumental in assisting individuals and societies navigating complex legal landscapes. Ma'am passion for breaking down intricate legal concept in accessible knowledge make her the perfect mentor for this workshop. So let's give a warm welcome. So before starting this session, I'm just delighted to introduce our incredible learning opportunity with our upcoming 10-week certificate course on women's law. This course is designed to provide a depth understanding of women's legal right, key legislation, landmark case law, and judicial interpretations. This courses will cover gender justice, protection against domestic violence, workplace harassment, and many more. So this course is a perfect for law student, legal professional, and anyone keen in advocating for women's right. So without any further ado, let's begin the today's session. Over to you, ma'am.
Thank you so much for this wonderful session. And I am grateful to Legal Vidya for giving me this platform to be a speaker today. Hello, good evening, everyone. Today's topic is going to be about the next 2 days. Be- Today, I will be covering the basic concepts of real estate transactions. So it makes the next 2 days much more simpler and easier for us to understand the concepts in much more detail. Allow me to share the screen so we may begin. I hope the screen is visible to all.
Yes, ma'am.
Okay, thank you. Also, any questions or any doubts at the end of the lecture, the seminar, I mean, the last 10-15 minutes we can cover them so that we don't end up breaking the flow of the seminar. So please do cooperate. If there is any doubt, I might take a doubt or two, but rest let's save for the end of the lecture. Today, the topic we are covering is going to be an introductory topic for all the real estate concepts. We will be covering most crucial part of it, the crux of it. We shall begin. Today's overview is mostly going to be understanding the property transactions and the type of property transaction that takes place. And also the focus is going to be on title due diligence and stamp duty and importance of registration of a particular property. So let's start with the first part of it, understanding the types of property. In India, most of the properties are distinguished between two types of property. First being a freehold property, in which there's an absolute ownership of the property and there's no time limit on the ownership of the property. I think yes. So in freehold property, a property where the owner has absolute and unrestricted ownership for an indefinite period of time. There are no limitations on transfer, inheritance, or sale. Example, if you purchase a standalone house in Mumbai and grant a complete ownership right, basically you purchase the land and also the structure on top of it. It will be a freehold purchase made by you, or a leasehold property wherein the ownership of the property is usually for a specific period of time as agreed upon in a particular lease contract. So this could also be say 99 years, 50 years, and so on. So that lease is valid for those particular number of years, and post that you need to renew your lease or the lease goes back to the original owner. Right. For example, Sidco properties or SRA, you all must be aware, these are leasehold properties. You have to take permission from government authorities and then you can initiate a transaction. If you want to sell a particular property, you have to follow that procedure. You have to follow that particular, um, you have to take that permission. You have to get a no objection certificate from them, and then you can transfer your ownership. I hope this is clear. Okay, going ahead, there are another two modes of property acquirement. First would be an ancestral property. This ancestral meaning what? Would your father's property be an ancestral property? Can anyone answer? Yes, like how Kirtana said, no, it won't be, as your father must have acquired by himself. But if it is not your father's property, if it is say pardada or a great grandfather's property, then that property would come under ancestral property, because ancestral property is across 4 family generations. So if there is say a plot in your village area, or a flat which is owned by your great grandfather, or a particular building is owned by a great grandfather, then 4 generations will be entitled for a share in that particular property. And then comes self acquired property. This is very simple, fairly simple. It is a property purchased or acquired independently by an individual using personal resources. The owner has full authority to sell, transfer, or bequeath as per his wishes. Example, a flat purchased solely by an individual, their own funds is considered as a self-acquired property. If your father owns a property or your mother owns a property, and don't have a right in that property unless and until they are deceased members and they have not executed any will or a gift deed or any transaction in that manner which establishes your right. So if say a particular flat, your father, mother, or anyone, if it is intestate, meaning there is no will executed, then it will devolve upon the legal heirs as per succession laws. basically class 1 legal heirs, class 2 legal heirs, and so on. Now let's understand the type of property transactions that take place. Okay, property transactions take place in unique ways. Basically, the most important ones would be, there are many modes, but we'd be covering a few. First being sale or an agreement for sale. Can anyone explain what's the difference between sale and agreement for sale? Someone asked me what's the difference between self-acquired property and a freehold property. It's a very interesting question. Freehold and leasehold comes to a particular land. It's about plot. Okay, if a building is constructed on that particular plot, then you will be having ownership rights pertaining to that particular flat, which can be on a freehold property, basically land, or a leasehold land. So you will be entitled to the share in that particular flat. I hope this makes sense to you. Okay. So coming back to the topic, sale and agreement for sale. When a particular amount is paid partly, then it is called an agreement for sale, because there are conditions as to, in a certain particular set period of days, if that sale completes, then that would be considered as a sale done. But a sale deed is when you pay that transaction in a whole. Basically, it's a one shot payment, and then that consideration that you pay in one whole payment is considered as a sale deed. And when you are partly paying or subsequently just taking a token, and you have, say you want to take loan, then you will put that there'll be certain conditions to it, basic that you'd be completing that loan transaction within 30 working days or 45 working days, as decided between the buyer and seller. So buyer and seller are the parties who decide those mutually decided transaction period. And post that, once that is completed, you have to add a clause in your agreement for sale that this will be treated as a sale deed if the transaction is over. But if you're not able to complete a transaction in that many amount of working days, then the agreement would be null and void. And thereafter, the procedure is very lengthy and tedious. Basically, you have to execute a cancellation deed because you did not complete that transaction in a particular time period, and then a cancellation deed is executed. And then the other mode is via gift deed or maybe mortgage. Now let's understand the difference between gift deed and a sale deed. A gift deed transfers property without monetary exchange. Basically, it's out of love and affection. If your father gives his property to you, though the stamp duty will be payable, it will be very nominal, but no consideration would be involved. And in sale deed, your father can sell a property to you as well, but then in that case it will be sale deed because consideration would be involved. So consideration being a very crucial part which decides whether it's going to be a gift deed or a sale deed. Let's understand what's the difference between a mortgage and a lease. A mortgage uses property as loan collateral. Basically, it's a loan collateral. It does not retain any kind of ownership by the borrower unless and until the repayment is done. So that mortgage is a collateral with a particular, say, NBFC or a bank, whichever party you go to for attaining that particular mortgage. And a lease grants you temporary sorry, pardon me, temporary usage rights. You will have rights to use that particular property for those many period of years. If a land is owned by a government authority like MHADA, SIDCO, or DDA, or any private entity and leased for a specific period, then in that case it will be considered a leasehold property. As we discussed, to sell or to transfer such a flat, the land owning authority, maybe it's a collector's land, then collector's permission would be required to make any kind of transaction further in that property. After the lease expires, the property lease needs to be renewed, or the land will be reverted back to the owner. Many flats in Navi Mumbai or Delhi are leasehold properties where land belongs to the government authority and the flat owners hold a long-term lease on those particular flats. All right. Let's understand that if a particular land, if a builder sells you a flat, okay, then will it be a freehold or a leasehold property? To understand this, we must understand that when the initial ownership structure is created by that builder, we execute a conveyance deed between the society and the builder. If that conveyance deed is not executed, then the property, the building structure, and the land will still belong to the builder. It won't be the ownership right of the society unless and until the conveyance deed of that land is executed between the builder and the society. And when a builder usually develops a property, he either owns the land or has leasehold rights. The builder constructs the flats and then sells them to individual buyers. But in many cases, no, land ownership is not automatically transferred to the housing societies. And now what will happen if there's no conveyance executed between the building and it's still remaining in the name of builder? Then the society won't get the ownership title for that particular land. And when the society decides to redevelop that particular property, it cannot, because it still doesn't have the ownership rights of the land itself. So then in that case, no, a conveyance deed, which is a legal transfer of ownership, is executed. And in such conveyance deed, a legal document is executed between the landowner or the builder and the housing society. And once executed and registered, the society then becomes the legal owner of that land and the building. And now, what if the builder doesn't come to the registration, or is, say, the builder is no more in the business? Then in that process, there's a process called deemed conveyance, where many builders fail or refuse to execute a conveyance deed, leaving societies without any legal ownership of the land. To address this issue, there is a process called deemed conveyance, and the process allows the society to get the land ownership transferred without the builder's cooperation. And there's a legal process that you need to follow, and within a couple of months, the process of deemed conveyance, and for that you have to go to district deputy registrar of the societies and start the process of getting an order of conveyance. And in that case, then the society becomes the owner of that particular land. So the conveyance deed can happen also unilaterally when the builder is not a part of the whole process. When he is not cooperating, or the builder is no more in the business, there are no replies from the builder, we don't know the whereabouts, then we can conduct the conveyance deed unilaterally. Now let's understand, now that we know that what are the types of property and what are the modes to acquire it, it's very important to understand that while we are in a process of acquiring such a title, why title verification is so crucial, we must understand in the following few slides. The title verification will ensure that the seller has a legal right to transfer the ownership of a property, may it be a land or a plot or a flat ownership. We need to verify the title so that the title is clear. And because we being homeowners, we invest our lives saving in a particular property, and just to later find out that the title was not clear in the first place. So title verification is crucial so that there are no hidden liabilities or disputes in future. Like there's no fraud. And without proper verification, a buyer may face a lot of legal complications and financial losses, and even lose the property altogether. In order to avoid this, title verification processes, we do it. Let's take an example, like if you buy a flat and then you discover that the flat was already mortgaged to a third party, or the owner from whom you did buy the flat just did not have any proper title in the first place, then that will lead to just incurring a lot of financial liability and losses, and also litigation, because if you take loan on that particular property and then initiate the whole process, then it's a lot of waste of time, efforts, and finances. So title verification will not only confirm the seller's right to transfer the ownership, but it also ensures that there are no existing claims or disputes and encumbrances in that particular property. It will help you prevent frauds like selling a mortgaged property and disputed property. And it safeguards against future legal complications or financial losses. There are just a few risks mentioned here if you skip the title verification. Now, who conducts this title verification? Usually us, we lawyers, we do take the title verification, wherein we generate a title certificate and then issue it to our client, and we have to be sorry, I have a very bad throat. We have to be the ones who are checking all the minute details, and then thereafter generating a title verification certificate and issuing it to the client. And if we are not doing it properly, then there are consequences also that lawyers face it in the process. So what are the key documents that one has to check while making title verification? The first one is a sale deed, which is the most primary document. It's very crucial because that will prove the ownership. Like, so, for example, A goes to B to buy a property. Does B have entitlement to that property? Does he have channel of documents? Who did B get the property from? There are several questions that need to be addressed. And then hence it's very important that the due diligence is happening properly. It means just basically investigation or legal audit to confirm all the material facts relating to history, title, or other privileges and obligations attached with it. In this due diligence, you will obtain sufficient and reliable information about the real estate market and that particular land or flat that you're interested in, if it is good, clear, and marketable title. The real estate due diligence is just not inspection and investigation of real estate property, but it's also important for business entities before a buyer makes a final financial decision. So a scrutiny in terms of legality, status, and user ownership is very important. So first thing we do is we check how the acquisition of that title of a particular flat or land is taken place. Is it via lease of land, Is it a partition of an HUF property? Is it a family settlement deed registered in the by the sub registrar? For example, if there's a flat and there's a will executed, then in certain states the probate is compulsory. Has it been probated? The court's order, are there any litigations? These are just a few things that you have to keep in mind as a lawyer before you make the title certificate. You also have to check the inheritance and succession while making a title verification process. If there is a particular mortgage, then is the mortgage closed? Is the dues paid? So then there is an agreement executed between the bank and the one who takes mortgage. You have to also check the huh, foreclosure agreement of the mortgage, or by gifts or relinquishment deeds. These are just a few registered conveyances and few other documents. What is a relinquishment deed? A relinquishment deed, or even known as release deed, in a property, there are a few legal heirs, okay? And the title owner is a deceased party now. Then in this case, we execute a release deed or a relinquishment deed if a legal heir wants to give up their share in that particular property to another legal heir. Then in that case, if someone attains that flat via a release deed or a relinquishment deed, then how did they do it? Were all the legal heirs considered along with that release deed or a relinquishment deed? It's very important that the person has also obtained a court order, which is a letter of administration order that you file in High Court of this particular state wherein the property is situated, asking the court to grant that order in your favor, and then also subsequently register a transfer deed or a release deed. To check the classification of that property, you will have to reach the government records by filing a form. You have to go to sub registrar's office, and I think there's form number 22 that you have to file with the sub registrar. It's a small form requesting the registrar that you want to conduct this due diligence and you will like to know what all government records hold in against that particular flat or land. So they usually have copy of a site plan or a survey number or a layout, a sanctioned plan of that property, so that the land, if someone is selling you a land, you can cross check that the size of that land and the layout that is there in government's office and government record are correct. They are in tune, and no fraudulent plan or a layout is being sold to you. So it's very important to check the sanctioned plans as well of the property, and by that you can identify that property structure, and that if there is an adjoining land, then what that land also entails. The documents should be certified by that land record officer. And to check whether the land is to be used for what purpose, like is it for agriculture? Because by default, at least in Maharashtra, all the land that is there by default, it is an agricultural land. For that you have to take a process, it is called as conversion certificate, wherein that agricultural land is then converted into a non-agricultural land. It is called an NA certificate or a conversion certificate, which you will have to check if you are purchasing a plot, and if it is not for agricultural purposes, if it is for your own use, then that plot needs to be an NA plot. NA is issued for residential purpose or for commercial purpose and many other purposes, for which if you want an NA land, then you have to. If you want to create a playground, then you have to check if there is a conversion certificate there. in the land records, and also the person will furnish that certificate to you. So the competent government or local body will take the fee of the conversion and they will issue the conversion fee, and the conversion certificate needs to be checked. Also, you need to ensure that the land is not subject to any proceeding by verifying the office of the Tehsildar and also by seeing the notifications issued by the local authorities. These are just a few processes that you can do just in title verification, basically the first document that you need to check. Then comes chain of document. To check chain of title deeds, basically if A sells it to B and B sells it to C, then what all you have to do is that you have to check that chain, that this was the first title deed, then thereafter what was executed. Because sometimes, no, a lot of people, it's at least in India, it's a very common practice that people on a stamp paper just execute a deed and sell it off to evade mostly stamp duty charges, or the person might not even have entitlement to that property, or that property could also be encroached. Just to sell it off, they might execute a sale deed and sell it off on a stamp paper. Recently, I spoke with a client. He came to me and he's like, "Ma'am, I have this document." So I checked that the document was executed on a 100 rupees stamp paper, and the person who he bought it from, his title was also conducted in a similar manner. This establishes no ownership, because for immovable properties, the title needs to be registered, and also people sell it by creating a power of attorney. Now, power of attorney is not a mode for purchasing a property unless and until it is registered, and it's registered in sub registrar's office for particular flat. Then those powers are established in that particular power of attorney, and only then someone can sign. It's just a signing power, and if selling power is given, only then that power of attorney is usable. But still, the court recommends that the properties being purchased should be executed between the title holder and the person who is buying the particular land or a flat. So, to ensure that the provisions contained in the title deed do not restrict the right of the owner, it is important to check that the title deed is executed properly, the requisite stamp duty is paid, and it has been registered under a registrar of that particular area. In case a property is held by an HUF, or if it's an ancestral property, then you have to also check the family tree and verify the death certificate of the original karta and in subsequent karta. Because in HUF, lot of times, no, if a partition deed has been registered, then it's a different story. But if it is not registered and an HUF is an ongoing HUF, then you have to check the death certificate, the original owner, who is the original karta now. If there is a will, then what will is executed, or a succession or a probate obtained from the court. To check the legal heirship certificate in a registered copy of partition deed. If it is executed, then you have to check a registered party. If there is a gift deed or a settlement deed, as the case may be in that particular HUF. In case a property belongs to a partnership firm or a society or a trust, you have to also check the partnership and trust deed of that particular property. And if the property is being sold by a certain official liquidator, then the court has to give an official authorized certificate to the liquidator. The order, official liquidator has to sell the land and property should also be verified whether if liquidation process has taken place, then has the court authorized an order for the liquidation process if you're buying it from a partnership or a trust. Or you can one must also inquire in government and municipal offices to ensure whether all the taxes on that particular property are paid, just not to evade tax liability from someone else. But when property taxes are paid, usually they are paid in the name of owners of that particular property. And you have to also check the municipal records of property taxes, and same needs to be confirmed and checked what they've furnished to you and cross checked with the government authority. There are more than one cases that one owner of the property my voice breaking? Letter of, it's not IOA, Dhruv, it is LOA, letters of administration. Basically, if someone dies intestate, there are three ways to go about it. You can file for an LOA without will, meaning intestate. And if you're a single child, then you can file for heirship certificate. If there are more siblings involved, then you file for letter of administration. Okay, I hope that's clear. You also have to check the OC, occupation certificate, in case of flat, and also you have to check the commencement certificate, that when you're buying a flat, you have to check in which year the OC was received, and is it a part OC or is it a full OC? Because if your flat has not received OC, then the builder has not completed his work. He has not paid all the dues, and he has not qualified to construct that particular floor for which the OC is pending for so many years. So you have to check the OC from the competent authority. If it is a builder, then you have to check if the builder has issued an OC. If it is SIDCO or MADA, then they give allotment letter. You need to check the allotment letter as well as a part of your title due diligence. If you purchase a flat, you have to check the registered title deed, the channel of document. Basically, in recitals part also, the channel of document is mentioned, but you need to cross check it with the original chain of document. You also have to check if there's an encumbrance certificate. Encumbrance certificate is mainly a certificate issued by a government authority, and in that particular certificate they mention that this particular flat, if there is any mortgage, third party created, or who is the owner is, all of those questions become clear in that encumbrance certificate. A lot of people forget this, especially in land. When a land is involved, you have to check encumbrance certificate. Even if you go and buy a flat, you have to check along with title deed. If parking is mentioned, then is there car allotment letter along with it? In land, you also have to check mutation certificate. Mutation is nothing but, say I am owning a particular land and then subsequently selling it to another person, then I have to mutate my record. Mutate meaning delete my name from the property tax or from the BMC authorities, so that I am no longer liable for the taxes to be paid in the future because I am selling that property. So such mutation certificate is not only important for the buyer, but it is also important for the seller, so that he is no longer liable for any kind of future disputes or tax evasion. Here we've mentioned Satbara extract for land in Maharashtra. You must have seen in any of the document that there is property card, Satbara extract. What is that Satbara Uttara? When the land originally was an agricultural land, it will have Satbara Uttara, basically land records for that piece of land. And a survey report happens, and that survey report thereafter removes a Satbara extract. Then conversion certification takes place, because first it's a Satbara Uttara because it's an agricultural land. If you're buying a flat in a building, the builder has to annex it, because who did he buy it from, and what were the old chain, what were the old property cards. So as an old proof, Satbara Uttara is also attached in that property document. Second is index 2. It is for flat, especially for flat, and a very crucial step. Index 2 is nothing but a government record. Whenever a document takes place, say even on a same day, you execute a release deed and a gift deed. Okay. In release deed, one party is releasing a right and giving it to another party. Say A and B are two legal heirs in a flat, and A releases his right and gives it to B, then B becomes 100% owner of that flat. Now B is also married and has a wife and wishes to give that flat to wife, 50% of it. Then when you go to a registrar's office, how will it get updated? First, B will get 100% ownership, 50% of his share and 50% that he's receiving from B. And then thereafter, he will give gift to his wife, 50% to his wife. Then the index 2 is the document which the registrar will update. Basically, first B's name will reflect, and then thereafter B and B's wife C, both of their names will reflect. So basically, if someone sells you a property, a flat, then you can check their index 2 even online. If you have property details, you can go to the state website, put the property details and check that right now, currently, in whose name is this flat registered. Hence, when you execute an instrument, it's very important to get it registered. Only then your name will get updated. In a lot of, it's a very common practice in a lot of cooperative housing societies that society committee members internally transfer the rights. Basically, some say a guy says that, okay, now my father is no more and he nominated me. In the nomination form, can you please update the share certificate in my name? The committee members many a times are unaware of the laws, and they just randomly, just on the basis of a nomination form, update their entries on a share certificate. It's not legal practice. It is not recommended. You need to execute a proper deed. If your father is no more, then you have to go to court, approach the court. If he's died intestate, get the court order, and then thereafter execute a transfer deed and submit it in the society, because a nomination form is mere on the basis of trust. When a father nominates his son in that particular flat, he's just trusting him for the possession of the flat, not the ownership of the flat. So index 2 is the document that you need to check. I guess we covered this. Why is NA in NA land important? Non-farmers cannot buy agricultural land unless it is converted. If you are not a farmer, You cannot buy an agricultural land with an intention to build something on it or sell in future. You can buy that land if only and only if you want to conduct the agricultural activities. And then I hope this is clear, whatever I've given, just the basics of it, basics of what we'll be studying for the next 2 days. I think I can entertain doubts. Rishabh, you can unmute the students.
Yes, ma'am.
Yes.
Yeah, hi Disha. Thank you for the session. It's been, the basics you really covered. Yes.
I'm so sorry.
I have a question.
Yes, sure.
Actually, you were explaining the Rera about Maharashtra, but about other states, how extent it will vary from state to state.
What is your doubt here? Like, what part is your doubt?
Overall, I am asking if it comes to Rera, how much it will change from state to
So
state.
land revenue records stay the same. Like here we call it Satbara. In Delhi side, I think they call it Khas Khajoni something. And
Okay.
in Tamil Nadu they call it Patti Katta Patti something. Okay, so just the names will change because I
Mhm.
practice here in Maharashtra. I know more about Maharashtra.
Okay.
But the names will change, but the land revenue record, no, they will remain same across all the states.
Okay. Okay.
So that particular
Hazra
state you have
Khatani.
to check.
Okay.
Khaja Khatani, right?
It's
Who's
called,
that?
yes,
Yes.
Sujit.
Yes,
Khazra.
Shruti.
It's Khazra
Correct.
Khatoni.
It's called Khaja Khatani, right?
Khazra Khatoni.
Khazra Khatani. In I think if it's in Delhi, right?
In UP.
In UP, correct. So just the name will change. Just here we'll call it Satbara, but in other states we'll call it appropriate name state wise.
Yes, ma'am. In
Okay.
most of the North India, it goes by the name of Khata and Kesra. So you can give the Kesra number and you can get the plot number and everything registered within the
Yes,
local. Right.
and you get the records. Correct, correct, Ashish.
Yeah. Okay.
In Rajasthan, it is also known as a RRG Sankhya.
Yes. Still, the crux of the matter remains the same. That the land revenue records will be maintaining those details.
Yes, yes.
Yes. All right. Anyone else?
Ma'am, I have one simple plain doubt as a law student.
Yes, sure. Go ahead,
Okay.
Ashish.
So if I want to like have a career in especially the real estate cases or
Hmm.
say real estate domain in general.
Right.
So what should be the initial steps? Like okay, going with the barracks, going with everything is one perfect thing. Second, what I am doing is like attending your session and all. But
Right.
apart from that, then what should be the just in a brief line or in a highlights if you may summarize. So that will be very helpful to us about other law students who might be interested in real estate.
Interested in making a career in real estate.
Yes, ma'am.
With real estate, no, more than bookish, the practical aspect is very different. Okay. So I would highly recommend any lawyer, young lawyer, wanting to make a real estate career, is first step would be to start interning under an advocate more than a real estate firm, especially under a advocate you can intern and gain knowledge, because practical knowledge will always prevail what you are studying here in bare acts, because real estate market is very unorganized. So first step I think I would recommend you would be to start an internship and then eventually move ahead and start your practice.
Okay, thank you so much, ma'am.
Yes, welcome.
Excuse me, ma'am.
Yes. Hi, is it? Who
Shraddha,
is it?
I'm Shraddha
Yeah,
actually.
hi,
Yeah.
Shraddha.
Yeah.
Let me.
Actually, I wanted to learn more about I wanted to learn more about the step-by-step process of doing a title verification. So,
Right. So
yeah.
I'll go in a flow. Okay.
Okay.
First,
So, huh. No, no. Are there any websites or YouTubes like which we can um watch to learn more?
yes, there are YouTube videos for every single topic out there. I'm
Okay.
sure there would be YouTube videos specifying, but if now that you've asked me, I'll definitely let you know
Thank you.
because we
Thank
covered a lot of basic concepts.
you.
We will go in detail ahead also, but I will
Okay.
just tell you the flow so that it's clear that if one needs to conduct a title verification, what needs to be done. First
Okay.
thing you need to check is the title deed. अगर तुम कहीं से किसी का प्रॉपर्टी लेने जा रहे हो तो क्या उसका प्रॉपर्टी है इन द फर्स्ट प्लेस एंड अगर है तो व्हाट विल ही फर्निश व्हाट ऑल टाइटल डीड विल ही हैव टाइटल डीड ओनली मींस title is a broader name. Under title deed it will come like is it a gift, is it a sale, is it via a release deed, is it via a transfer deed. So you will have to check the title first thing. Then you have to check the channel document. Channel document as in now that person has established the title, you verified also okay his documents are perfect. Now what about from whom he purchased and the person before that, right? Because we
Mhm.
need to check all the channel of documents. A lot of times what happens, no, people create fraudulent documents in between, okay, and then establish the title, correct? If
Okay. Yeah. Yeah.
and also one more important thing here would be, are the stamp duties also paid? Because a lot of time you go and purchase a flat and you just get to know that already purani duties clear nahi hai. So
Mhm.
for that, at least here in Maharashtra, there are processes like amnesty. Okay. So has it been adjudicated later? You have to check that. Okay. And then you have to also check the chain of document. For example, अगर share certificate पे original owner का नाम है, then you go on the back side and then you check that okay there are 5 names, but he's given me 4 channel of documents. Then what? Why is the fifth part missing?
Mhm.
Right? Is there an ongoing litigation? Has it been mortgaged? There could be an number of things. But being a buyer or being a lawyer, I think I can say lawyer because most of y'all are lawyers. Being a lawyer, first thing you need to check is channel of document. Then thereafter, you will check the encumbrance certificate. Here in Maharashtra, you have to file a form with sub registrar. The form number is 22. The form will change, but again, in across all the states, you have to go to sub registrar of that local authority, and then you have to file a form, and then the registrar within 15 to 30 days he will respond back to you. What are his discoveries? What are his findings? Okay. Then
Yeah.
you need to check OC also and allotment letter also. If that abhi sab theek hai, okay, title is perfect, the channel of document is great, encumbrance certificate is not there, but is there an OC for that flat? Has the builder received OC to construct, say, on 19th floor? Okay, OC is up till 15th floor, and if you're buying on the 19th floor, would it be right?
No. No.
Right, he's not cleared dues till 19th floor, then he
Mhm.
doesn't have a allotment right. A builder will only get an allotment right if he has obtained the occupation certificate from the authority. Okay, then you have to check the tax receipts or as many of you all might know, assessment bill. Okay, It's a particular RN number on which every year you pay taxes, correct? Either it could be individually or society as a whole might be paying, but you have to check whether that bill is there or not, correct? Then in case of land, you also have to check the mutation certificate. म्यूटेशन सर्टिफिकेट में तुमको दो चीज पता चलेगी. इज देयर द करंट ओनर who's approached you to sell that land, is his name there? Because a lot of time he's also done the deed but he has not mutated, then government records won't reflect his right.
Right.
You have to check the mutation certificate. Mutation is equal to delete. Okay, yeah, mutate we call, right? You remember this because you might get confused between encumbrance and mutation. Encumbrance is for checking if there are no mortgages or no obstacles. Okay, and mutation is for checking that the recent owner who has approached to you, is his name there in the land records. Okay, so mutation certificate is also, you can check it online, state-wise. Then you can check the conversion certificate. Conversion certificate is basically when a Satbara gets converted into an NA, a non-agricultural land. Like in Maharashtra, it's Satbara. We've discovered that there are different names for different states. So you also have to check the conversion certificate. This will be your last step.
Okay. Ma'am, can I have your email ID or number if I require any further, doubts?
Sure. I will definitely share it here in the chat box later on.
Okay. Thank you. Thank you so much.
Welcome.
I do have a query.
Yes, please,
Uh,
Sachin.
s- yeah. Suppose a person has sold his agricultural land to person B,
Right.
and B fails to get his get his name updated in Khasra Khatoni.
Hmm.
So, as means legally, A is the in records, A is the owner of that property,
Right. And he's also the taxpayer. Correct.
taxpayer. Yeah.
Hmm.
So, can A sell the property again on the basis
No,
of those
A can
documents?
definitely, and that happens also. A will, same piece of land is sold to more than 4 or 5 people at the same time. They
Yeah.
execute fraudulent sale deals.
Yes.
And hence, once you check Khaza Khatoni, and if B is coming to you and B ka naam hai, then you will also be assured that okay, he is also paying taxes and also his name is there registered.
No, in case, because as per my understanding, the records takes time to get the name updated, at
Yes,
least
you
6
have to
months.
wait. Yes, you have to wait for.
सपोज आज किसी ने लैंड सेल कर दी और एक हफ्ते
Hmm.
बाद और नियर अबाउट 2-3 दिन बाद ही किसी और को भी सेल कर सकता, तो आई
तो इसीलिए
बिलीव
हम एनकम्बरेंस सर्टिफिकेट भी निकालेंगे. एनकम्बरेंस सर्टिफिकेट आपको 1 महीने के अंदर मिल जाता है अगर उन्होंने कहीं और टाइटल क्रिएट किया है. ओके, बी ने दूसरे लोगों को भी बेचा होगा तो वो रजिस्ट्रार के पास जाना पड़ेगा, राइट?
Yep.
और अगर वो रजिस्ट्रार के पास नहीं गया, ओके, बी ने किसी और को बेच दिया विदाउट गोइंग टू अ रजिस्ट्रार, और वो आपको बेच रहा है और आप रजिस्ट्रार के पास गए, ओके, जिसका भी रजिस्टर्ड डॉक्यूमेंट होगा ना, वो प्लॉट उसे बिलोंग करेगा.
So on the basis of that record number we can check, मतलब रिकॉर्ड नंबर से हम चेक कर सकते हैं कि भाई खसा खतौनी का ये
जी.
नंबर है. ओके ओके
जी.
ओके,
एंड
गॉट इट.
एज वी डिस्कस्ड, स्टैम्प ड्यूटी भरना तो पड़ेगा, राइट? सो इफ यू आर
Obviously,
गोइंग देयर एंड पेइंग स्टैम्प ड्यूटी, तो आपको तुरंत आपका भी एप्लीकेशन डालना है दैट नाउ यू आर, वो पर्सन विल पुट एन एप्लीकेशन फॉर म्यूटेशन एंड यू विल पुट एन एप्लीकेशन दैट नाउ यू आर द वन जिसके साथ म्यूटेट होगा. एंट्री पास होता है बेसिकली.
ओके ओके ओके.
बट लैंड में बहुत लिटिगेशन ऐसे ही नहीं है, बहुत फ्रॉड होता है. इतनी सारी चीजें चेक करने के बाद भी कहीं ना कहीं लूप होल्स होते हैं.
Exactly.
सो आई विल से दैट दिस इज, you have to do all of this. Still there are loopholes, still there are people, मतलब कई बार है ना ऐसा डीड बनाएंगे गलत, सब रजिस्ट्रार भी बोलेंगे कि ये है बट वो सब रजिस्ट्रार भी नहीं होगा, गलत स्टैंप भी बनाएंगे, उतने हद तक फ्रॉड होते हैं। और वो लॉ
Yes,
फॉर्म्स भी चुक जाती है, मतलब इवन लॉ
exactly.
फॉर्म्स आर नॉट एबल टू फिगर आउट दैट दीज आर द लूप होल्स।
Hmm. Agree.
Yes,
Thanks, ma'am.
welcome.
Ma'am,
Thank you, Palak. Yeah, I'm actually under yeah, it's been going well, and I'm glad that this session was insightful, and I like such interactive sessions.
ma'am,
Yes.
my query was regarding HUF. You
Hmm.
explained bit, but I skipped to write it. So can you
Hmm.
please tell which all were the requirements?
So the requirements will remain same. The only thing that you have to remember for HUF would be कि if partition has happened, okay, partition in an HUF, then partition deed should be registered. Okay. Rest all the requirements remain same.
Ma'am, but
And
which all are the
especially
requirements?
just what I told, no, the title deed, channel of document, all the requirements would HUF won't be treated very differently.
Mhm. Title
Okay.
deed, channel of documents, and
I think someone has written here in the comment box. Soumya has written, right?
Mhm.
See, she's written all the 9 points that I've explained.
Okay. And ma'am, do you have an internship opportunity at your chamber?
If in case something opens up in future, I will definitely let you all know.
Okay. Thanks.
Okay, thank you. If someone Jyoti has asked, if someone buys agricultural land, so does that person is that person liable to build a land or build a building on it or not? No, they won't be. They can't buy an agricultural land with an intention to develop a building. If they want to convert that, they can buy agriculture. A lot of people do this. They buy agricultural land because they are at a much lower rates, and then they start the process of converting that agricultural land into a non-agricultural land and obtain the conversion certificate. Once you obtain the conversion certificate, thereafter you can definitely build a home or a building by taking appropriate competent authorities permissions. Palak, you've asked me, no? This we will be covering in tomorrow's lecture. We will be taking up Rera, and we will be understanding Rera in detail. Anyone else? Okay, I think this was it.
If anyone have any query, kindly unmute yourself and ask.
Yes, I
Uh,
have a question.
okay, Varun.
Yeah, so like I have a case that received today.
Hmm.
Um, the buyer and sellers both are dead. The
Hmm.
demised.
Hmm.
So the buyers have four siblings, four childrens,
Hmm.
and it was like the buyer sold agriculture plot to the seller sold agriculture
Hmm.
plot to the buyer,
Correct.
and buyer is a lady, was a
Right.
lady,
Right.
and she is also passed away now.
Correct.
Now the partition suit has been filed by one of the their
Legalize.
legal hire.
Hmm.
Now it found that the registry was done, but it has some errors. Like
Hmm.
Khasra Patani was wrongly mentioned. The
Hmm.
location of the location of the plot,
Hmm.
belonged to some other Khasra Khatani,
Hmm.
whereas the registry had mentioned some other Khasra Khatani.
Right.
So what is going to happen in this?
Hmm. This was a very interesting
Complicated.
now because it's very complicated, especially because when you are not properly mentioning the plot only that you're buying, then for first and foremost thing, if there is a legal complication going on, okay,
Yeah.
by the old legal airs, the first thing that would be considered would be how the right then gets established because there were other legal airs, right?
Yeah.
So that will always overtake the existing title deed.
Yeah. So now the thing is, the occupant of the property
Hmm.
approached me, and
Hmm.
the other three legal here hires
Hmm.
are not occupying the property. Now
Hmm.
the occupant of the property approached me, and he is claiming the rights of the property, right over the property.
Hmm.
Why? Because he's saying it is he's saying that it is like he's occupying the property since 20 years.
Right.
So it is the absolute right of the property, like
I will give you an interesting example. My old housemaid, she had
yeah.
ancestral right in one of the properties on which a building was standing, and she went to a lawyer. He took a pro bono case. She
Okay.
had an ancestral right, and she got compensated more than 20 crores, if I'm not wrong.
Oh, that's
So,
great.
hence, when we were going through the ancestral part, that will always prevail, and hence, buying a property is quite a troublesome task.
Yeah.
You have to check the property from every angle.
Yeah. You know, on the like
I'm sure they
you
must have not done all the your
yeah,
क्लाइंट नो उन्होंने नहीं किया होगा टाइटल डीड का
their names
वेरिफिकेशन
also,
क्योंकि
yeah,
नहीं होगा उनके पास कोर्ट ऑर्डर नहीं होगा बेचने का प्रॉपर.
no. The seller had the rights of the property because he was the owner of the land, particular land.
बट उनको कहाँ से मिला वो? it if it goes
It's
back, did he have everything? Because see, if he, yeah, so he must have hidden legal heirs. Lot of people do that. Even in release deeds, say there are 4 siblings, okay?
Yeah.
They just show that there are 3, and 2 of
Yeah.
those are giving it to the third person, and the fourth
Mm.
is completely omitted. But then it's a crime, it's fraud. अभी वो
It-
चौथा फल उठ के जाग गया, and you've checked everything, even the government records are reflecting the same, it will still turn into a suit and a stay order would be. Yes.
अब तो उसमें हो गया like the that is all that part is already settled now. क्योंकि जो बायर था वो सेल करके ही इज पास्ड अवे. द सेलर एंड बायर बोथ आर नॉट अलाइव नाउ.
Correct.
अब तो उनके आगे वाले लीगल हेयर्स अपने पोजीशन लीगल राइट्स के लिए फाइट कर रहा है.
Hmm.
बड़ा
Hmm.
सन है, ही अप्रोच्ड मी and he is saying that he is occupying this property and he has the right over the property.
No, no, of course he doesn't, it doesn't work like that, no.
Adverse possession, he's saying, it is like it is my right because he is living at the property. Other three legal heirs are not living staying on the property. So, like, I'm just finding the ways out
Hmm.
how to deal with the situation. You know, I, मैंने check किया तो I didn't found the names of the buyer in the Khasra Kotoni.
Hmm. So basically, if the records would have been properly checked, this would have been a mistake avoided. There is
Yeah. So
obviously, I don't have the documents on my hand to check, right? But there
yeah.
would be a loophole on which a suit will be filed later on. Or anyway,
So
anyone else having any doubts?
I think, ma'am, there no one have any doubt, so we can wind up this session, ma'am. We can wind up this
Thank
session.
Thank you so much, everyone. Thank you,
thank you.
legal.
Thank you, ma'am. Thank you, everyone.
Thank you
Thank
so
you,
much,
ma'am.
ma'am, for sharing your expertise and making the complex legal concept so much clear. And also a big thank you all the participants for your active engagement. We look forward to seeing you all again tomorrow. Until then, take care and keep learning with Legal Vidya. Thank you, ma'am. Thank you, everyone. Good night
Thank
to you
you.
all.
Good night, everyone.
Thank you, ma'am and sir.